Get ready for a deep dive into a case that starts in the darkest corners of the internet and ends in a high-stakes courtroom showdown. We have 24-year-old Arturo Contreras Santos, a man who pleaded no contest to 5 counts of possessing illicit pornography. But this isn't a simple sentencing. His defense is about to roll out a complex and controversial strategy, bringing in a psychologist to argue that the defendant's mind itself is the reason for his crimes. They'll suggest everything from cognitive disparities to a potential autism spectrum disorder. The prosecution, however, sees it differently. A man who knew his actions were illegal and victimized children and did it anyway. The judge, Stephanie Boyd, has to weigh a plea for therapy against a demand for prison. With a 10-year sentence on the table, every word of testimony could determine the rest of this young man's life.
Had someone who is merely trying to change their tire, and now they're dead through no fault of their own. So that's an issue. Gonzalez, are parties ready? All right, are you ready on Gonzalez? No. Okay. All right, the court is calling 2021 CR 9984, State of Texas versus Jose Gonzalez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Alfonso Cabañas for defendant Jose Gonzalez.
And are you Mr. Gonzalez? All right, you're gonna need to keep your voice up so that the court reporter can hear. And so that I can hear. You entered a plea of no contest to count 1 for the offense of on June 13. According to the plea bargain agreement, punishment is to be assessed at a cap of 35 years in the prison. There's an affirmative finding of deadly weapon, and there are 2 cases that are being taken in consideration. All right, state, do you have any witnesses?
Not for the sentence.
Defense, any witnesses?
Yes, Judge, only Mr. Gonzalez, but I don't know if the court wants to allow him to talk or.
Right out of the gate, the prosecutor makes a critical move, a motion to seal the evidence. This isn't just procedural paperwork. When a prosecutor asks a judge to seal evidence, it's a massive red flag that the content is so graphic, so disturbing, or so sensitive that it cannot be part of the public record. The motion specifically mentions a flash drive, likely containing the material at the heart of these charges. By agreeing to this, the defense and prosecution are sending a unified silent message to the judge. What we are dealing with here is exceptionally grim. This single action immediately sets a dark and serious tone for the entire proceeding, removing any doubt about the gravity of the offenses before the court even hears a single witness. It frames the defendant's actions not as a simple mistake, but as something profoundly disturbing.
You wish to do it if I'm going to swear him in, if he's going to be doing it by narrative and the state has no objections, then we can proceed by narrative.
And we can do that, Judge.
All right. State, will you have any objections to proceeding with testimony from the defendant by narrative? Of course, you'll have a chance to cross-examine him.
Good, Judge.
All right, can you raise your right hand for me, Mr. Gonzalez? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please.
Gonzalez Jr.
All right, and
The defense's strategy now comes into full view as they call their star witness, Dr. Michael Jumas, a clinical psychologist. This is a classic sentencing hearing tactic. The battle is no longer about guilt or innocence. That's already been established by the no contest plea. Now the fight is over the why. The defense is trying to reframe the narrative from one of moral failure to one of psychological impairment. They want the judge to see Contreras not as a predator, but as a troubled individual with undiagnosed issues who needs treatment, not a prison cell. By introducing an expert, they are attempting to add a layer of scientific credibility to their plea for mercy. The entire goal is to mitigate his culpability and convince the judge that rehabilitation on probation is a more appropriate sentence than pure punishment.
is there something you wish to inform the court of? All right, yes.
It is your desire, Mr. Gonzalez, to talk to the judge about the sentencing today and tell her what it is you feel or what it is you want her to know about the sentencing, correct?
And I take in full, I take full responsibility for what happened that night. And it wasn't intentional. I was under the influence. I made some bad choices and even worse decisions. And I just want the family to know that I truly am sorry. This isn't my character. I was out of character this night that this happened. And I know how I would feel if this would happen to one of my family members, and I just want the family to know that it wasn't me that night. Like I said, I had some things go wrong in my life, and I made bad choices, and completely am sorry for it. I can't say it enough or express how truly sorry I am and remorseful. And I know that not only do they have to live, not only do they have to live with it, but it's something that I have to live with the rest of my life. And I truly am sorry from the bottom of my heart for everything that I caused and for all this that I brought up, and I accept full responsibility.
All right. Any other questions for your client?
No questions at this time from Mr. Gonzalez, Your Honor.
State.
Yes, Your Honor. Mr. Gonzalez, you saw the PSI report with your attorney, is that correct?
Yes, sir.
I'm sorry, you just need to speak up.
Yes, sir.
Thank you. Is there anything that from your statement in here that you would like to retract from what you talked about, especially about the actual incident that night?
This is a masterclass in judicial transparency. Before the expert witness can even begin his testimony, Judge Boyd stops the proceedings to make a full disclosure on the record. She announces that she knows Dr. Jumis professionally from her time as a defense attorney, having hired him for cases herself. This is incredibly important. By putting this potential conflict of interest out in the open, she gives both the prosecution and the defense the opportunity to object. It ensures that her final ruling cannot be questioned later on the basis of a hidden bias. Both sides state they have no objection, which allows the hearing to proceed on solid ethical ground. It's a small moment, but it speaks volumes about the judge's commitment to maintaining an unimpeachable record of fairness, which is crucial in a case with such serious implications.
Because the reason I ask that is because you said today in court that you're taking full responsibility for it.
Yes, sir.
Now, the problem is that in this report, and I'll read from it, it says that the person that you ran over tried to hit you with a tire iron.
Yes, sir.
And then you also stated that he jumped in front of the truck 2 different times.
Yes, sir.
And then the second time is when I ran him over.
Yes, sir.
But you do realize that he walked in front of that vehicle. I have a video that I'll be showing you shortly. And he came over to the driver's side. You recall that?
Yes, 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 sir.
And you're in the driver's seat. And you drove forward. And then you backed up. And then that person, probably ran through you, walked in front of the car and got into the grassy area. You recall that?
I'm sorry, just 1 second. Excuse me. In the box, if you all cannot whisper, do not talk. We're on the record. You may continue.
Do you recall that? He got out of the way of the vehicle. He was getting out of your way and you turned the wheel and drove directly over him. Do you recall that?
I turned the wheel to the right. He was standing in front of the driver's side in front of me, and I turned the wheel to the right to try to veer off and go around, but there's only so far because there's a ditch right there.
Okay.
That I was for.
You saw the video, right? You're gonna have an opportunity to see it again. Okay.
Yes, sir.
So I might give you the benefit of the doubt, considering that you're intoxicated at night. Why don't you tell the judge, what were you on that night?
Meth, marijuana. I don't even know what else.
Xanax?
I don't even remember taking Xanax, sir. But if I was, I was.
And also, just going to your record, you just got out of prison,
Yes, sir.
and then this happened.
Yes, sir.
And so the way I read this is that you're stating that it was the victim's fault that you ran over him.
I'm not gonna say it was all completely his fault, but I mean, if it's seen like on the video, I tried to go around the passenger side. I was trying to avoid a situation that happened at the gas pump, period. And that's what I was trying to.
Here we see a significant crack forming in the defense's expert testimony. When asked if he's aware of the facts of the offense, Dr. Jumis admits he only has a thumbnail sketch and that the defendant never described the charges to him. This is a crucial admission. How can a psychologist offer a complete opinion on the mental factors contributing to a crime if they aren't familiar with the specific details of that crime? The prosecutor is surely taking notes. While the doctor can speak to the defendant's general cognitive functions and developmental history, his inability to connect those findings directly to the criminal acts in question weakens his entire analysis. It opens the door for the prosecution to argue that his evaluation, while clinically interesting, is ultimately speculative and detached from the reality of the offenses committed.
Get away from.
So I mean, you just said not all of his fault, or possibly his fault. How is it any of his fault?
I mean, it's not his fault. I mean, it's we were both at bad places, at an even worse time. And I mean, I know he was just changing his tire, but at the same time, when I approached him, if I recall correctly, I told him like, hey, I wanted to try to get out of it, period. And when I asked him for a ride, it just, I don't know, he wasn't. I guess because my demeanor, I had my shirt off, I have tattoos, maybe I was.
I mean, you're a gang member, right?
No, sir, I'm not.
You're not part of the Mexican mafia. That's what was dictated in here.
I understand it was dictated, but no, I'm not.
What's the Playboy bunny behind your ear?
It's just a Playboy bunny.
Just a Playboy.
This is the core of the defense's argument. Dr. Juma suggests that Contreras may have an undiagnosed autism spectrum disorder or attachment disorder, and the defense attorney immediately seizes on this. He frames it as a potential diagnostic that could be explored further with therapy under community supervision. This is their Hail Mary play to present the defendant's crimes not as a result of malice, but as a symptom of a treatable condition. It's a powerful appeal to the idea of rehabilitation over retribution. The expert carefully avoids stating the defendant is autistic, but by raising the possibility, he gives the defense the ammunition they need to argue for a second chance. The central question for the judge now becomes, is this a genuine psychological issue that warrants leniency, or is it a last-ditch effort to avoid a prison sentence?
Yes, sir.
That's not related to the technological horns at all.
No, sir. The Oregon horns and the Mexican mafia.
I know they conflict. Let's see people can switch sides. So do you remember approaching him for the first time? You approached him twice.
Oh, I don't.
And so you approached him once, had an altercation with him, you walked to the gas pumps, and then you walked across the road. Do you remember that?
No, sir.
Do you remember being in the median with your boxers down, your shorts down?
No, sir.
And do you remember walking back and talking to people at the gas pumps again?
Sir.
Do you remember going then to the victim's truck when he was on the passenger side trying to change his tire?
When I remember was when I walked up to him when he was at the driver's side and he was standing there with that, I guess, the tire iron in his hand.
To be fair, he's changing the tire. So what would you have in your hand if you're changing the tire?
I mean, I understand that.
Well, you stated here that he hit you with it. Do you recall that, or you just say that?
No, I said he swung it at me. I never said he hit me with it.
Okay. Well, because in here it says that I closed the door and the guy was standing there with the tire on. Was that the individual, the victim that you're talking about?
Yes, sir.
Did he ever bash on the windows or anything like that, trying to get you out of that truck? It's on video, so I want to know if you remember.
I don't remember. I'm not gonna talk.
Do you recall saying that there was another guy in the truck and he was closing the door and that there was a girl in the truck that you're trying to help?
That was the first truck that I brought up on.
Now, to be fair, you don't know those people over there by the gas pumps either.
With the expert testimony concluded, the defendant himself, Arturo Contreras Santos, now takes the stand. This is the ultimate high-risk, high-reward moment for the defense. All the clinical evaluations and legal arguments now give way to the raw, human element. This is his one and only chance to look the judge in the eye and personally convey remorse, responsibility, and a genuine desire for change. His demeanor, his tone of voice, and the sincerity of his answers will be scrutinized. He needs to convince the judge that he is not the person who committed those crimes anymore and that he can be trusted to follow the rules of probation. His family is in the courtroom watching, and the weight of their support and his own future is squarely on his shoulders as he prepares to answer for his actions.
I talked to them and they don't know you.
Yeah. They know it.
And it states in here that you said that you were trying to steal the truck. Is that right?
No, I never said I was trying to steal the truck.
You said, I told the officers that I was trying to steal the truck, but that's a lie.
I told the officer I was trying to steal the truck, and I said that's a lie.
Yeah. But you know that you weren't supposed to be in that vehicle, right?
Yes,
And that was not your vehicle.
yes.
Judge, at this time, I'd like to use state exhibit, I believe, number 2 that was entered for stipulated steps to show and see if you can identify portions of that.
Any objection?
No objection, Judge.
All right.
At this time, I'm going to be playing at 22:44:04. Sir, you see that person right there?
Yes, sir.
And is that you?
Yes, sir.
And that's you with your
The prosecutor's cross-examination is short, sharp, and absolutely devastating. In just a few pointed questions, she completely dismantles the narrative of a confused young man who didn't understand his actions. She forces Contreras to agree that intimate relationships with children are wrong and that possessing this material is illegal. Then comes the kill shot. You knew it at the time you were doing it, and you did it anyways. The defendant's simple "yeah" is a fatal blow to his plea for sympathy. The prosecutor surgically removes any ambiguity about his state of mind. This wasn't a mistake born of cognitive dissonance. It was a series of conscious choices. She effectively argues that any psychological issues he may have are irrelevant because he understood right from wrong at the moment of the crime and chose wrong.
shirt off at that. Is that correct?
Yes, sir.
Where are you approaching? Can you see? Who's that you're approaching, sir?
No idea.
Is that the truck?
The arguments are over. The testimony has been heard. Now, it all comes down to Judge Boyd. The courtroom hangs in suspense as she weighs two diametrically opposed narratives. On one hand, the defense presents a 24-year-old with no prior criminal history, a supportive family, and a potential underlying psychological condition like autism that they argue drove his behavior. They are begging for rehabilitation, for a chance to get him help under supervision. On the other hand, the state paints a picture of a calculated adult who knew his actions were illegal and harmful, who victimized children with every click, and who made a conscious decision to break the law. They are demanding punishment and a prison sentence to reflect the severity of the crime. The choice is stark mercy or justice, a path to therapy or a path to a prison cell.
Can you see what that is? You see that there's a person on a bicycle there too, is that right?
Yes, sir. I can.
And you know that individual.
No, sir.
So he's standing there while you're at that truck. Is that correct?
Yes, sir.
Did you see yourself walk off there?
Yes, sir.
Okay. That's the first time you approached the victim at his truck. Now I'm going to 22:50:33. I'm going to start playing it here. Can you see an individual at that truck in a white shirt? He just walked around. He just walked around. There's a glitch. Now you're going to see another person walk up right here. You know who that person is?
Can't see that good from here.
I'm sorry.
Can't see that good from here.
Well, I'll tell you, that's you approaching him for the second time, roughly 6 minutes later, after you left him the first time. You approach and you go to the side of the vehicle. He just walked around. There's a glitch. Now you're going to see another person walk up right here. You know who that person is?
Can't see that good from here.
I'm sorry.
Can't see that good from here.
Well, I'll tell you, that's you approaching him for the second time, roughly 6 minutes later, after you left him the first time. You approach and you go to the side of the vehicle.
The hammer falls. Judge Boyd finds Arturo Contreras Santos guilty on all 5 counts and sentences him to 10 years in prison. The defense's psychological strategy has failed. Despite a compassionate final word to the defendant that his life isn't over, the sentence is firm and unequivocal. But just as the gravity of that decade-long sentence sinks in, the courtroom pivots to a completely different case. The judge's entire demeanor shifts. We are now introduced to a new, unnamed defendant, And instead of discussing punishment, the judge is actively trying to get him into mental health court. She's even offering to let him withdraw a previous plea if he's accepted into the program. The contrast is jarring and immediate. We've gone from a case of strict punitive justice to one of proactive rehabilitative intervention in a matter of seconds.
Lights come on. You see the victim walk in front of the truck, go to the driver's side. You know who's behind the wheel at this point?
I am.
Looking at you. Drive forward where you could have driven off at this point, but you chose not to. You reversed and turned the wheel. Now you have the victim in the middle of the vehicle. He walks off into the grassy area. You turn right, and run directly over him.
What we're witnessing here is a fascinating look at the different paths available within the justice system for this new defendant. Judge Boyd is exploring a mental health court diversion program. These are specialized courts designed to handle cases involving offenders with diagnosed mental illnesses. The goal isn't just to punish, but to provide court-supervised treatment and support to reduce recidivism. The judge is going out of her way to facilitate this, coordinating with court staff to get the man screened, and even promising to grant a motion for a new trial if he's accepted. This stands in stark contrast to the previous case. While Contreras' defense suggested a potential mental health issue, it seems this new defendant has issues that are more clearly established, prompting the judge to pursue a therapeutic route instead of a purely punitive one.
To the grassy area. You turn right, run directly over him. Do you recall that?
No, sir.
Second portion here. You ram it into the Texaco. It didn't end up there. You rammed it into Texaco. You'll see you exit the vehicle. Nobody else in that vehicle. Witnesses are going out to check on the victim in the middle of the field. You continue to walk inside of the gas station. Do you recall that?
Yes, sir. Walking in the gas station, yes.
I'm sorry, 2254-17. Is that you?
Yes, sir.
Let's get the facts straight. She loves a verbal ashtray. Never blowing smoke when she gets pissed. She's quick to castrate. Love her on a good day, love her on a bad day. Either way, she's here to stay, stay, stay. Call up Holy, 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 Holy Lucy. Holy, 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 Holy Lucy. Holy, 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 Holy Lucy. Holy, 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 Holy Lucy.
Is this you? Do you know who you're talking to at this point?
No, sir, I don't.
Talking to officers that have come in to arrest you. As officers approach, you retreat into a small office. And that's where they have to enter. And that's where the cases that are being taken into consideration of you kicking two different officers. Do you recall that?
No, sir.
So in saying all this and showing you these videos, you state in this statement here that I'm hoping they see the videos and reduce this to a manslaughter. Do you recall that?
Yes, sir.
And so at this time, do you believe that this is a manslaughter?
No, sir.
Pass my witness law.
Defense?
Judge, just to clarify a point that I think was just misread by the state. In reviewing the PSR, I think the statement was, and if this is correct, Mr. Gonzalez, they told the officers that I was trying to steal a truck, but that's a lie. All right, so you never told the pre-sentence investigator person you were trying to steal the truck. It was whoever told them that it was a lie. You weren't trying to steal it. And then based on what we saw, Mr. Gonzalez, you were under the influence of several drugs, correct?
Yes, sir.
Nothing further, Judge.
State, any further questions?
Not to this witness, Your Honor.
All right. Any other witnesses, defense?
Not from defense, Your Honor.
All right, then the court will hear argument. State,
Full reserve for closed, Your Honor.
defense.
Thank you, Judge. I think what we just saw, Your Honor, on both video and what we heard from Mr. Gonzalez are the unfortunate consequences of an individual who was heavily intoxicated by multiple drugs. If the court reviews the PSR, it will see that prior to this incident, Mr. Gonzalez did not have any assaultive offenses. It was nothing but drug use, for which he did his time and was on parole. From the beginning of my representation of Mr. Gonzalez, Your Honor, I want the court to know that Mr. Gonzalez has been very apologetic for that night, for the death that he caused, and for the terrible loss that it caused to the victim's family. He's never once, Mr. Gonzalez, he's never once told me that he wanted to fight this case or take this case to trial. Nonetheless, we reviewed discovery, we saw the video, we saw the reports, and it is confirmed through the evidence and his testimony that he was heavily intoxicated by use of meth. The court just saw his behavior was erratic. As Mr. Gonzalez said, it's completely out of character for him that evening. But as a consequence of his drug use, Your Honor, there was a person who died, and for whom Mr. Gonzalez expressed his remorse and also his sorry to the family. And I say that, Judge, because I want the court to consider what Mr. Gonzalez said, the PSR, but more importantly, in acknowledging that Mr. Gonzalez from the very beginning accepted his guilt. Regardless of what the state asked him or regardless of his answers, you can tell that Mr. Gonzalez has difficulty expressing himself. But I want the court to know that in no way did Mr. Gonzalez ever or today try to minimize his guilt or put the blame on the victim. He accepted responsibility. He told the court he was under the influence of drugs. And he didn't. Done that even better. And so with that said, Your Honor, I would like the court to consider a punishment, thank you, to consider a punishment for Mr. Gonzalez of 20 years incarceration.
All right, state.
Yes, Your Honor. Victim in this case, Mario Renteria, is just trying to fix his flat tire. Pulled up in that gas station where he'd been numerous times before. Within the testimony that he was there quite often to go get a drink before he goes to work or anything like that. That he was a frequent individual that came by there. He was a nice man, that he was just there to change that tire. And what ended up happening to him that night is egregious. This individual, Mr. Gonzalez, has pled to this case, but the fact is that he hasn't answered for the case yet. And the fact is that he approached the victim 2 different times, and witnesses would have testified, and in the prosecution guide, that Mr. Renteria was not aggressive, that wasn't attacking Mr. Gonzalez at all, was trying to get away from him at times. And you can see from the video that the state has provided to the court and shown to the court that the victim walked in front of the car 2 different times, and the defendant had an opportunity to leave in that stolen vehicle if he wanted to leave. But he chose to turn that wheel to the right and run over Mr. Renteria directly. And so in saying that, Your Honor, I want to go over a portion of what the autopsy shows of the damage that the defendant caused. Both femurs, both legs were broken in half. Pelvis had multiple fractures. He had a broken back, mid-back, and the thoracic. He had a lacerated liver. He had a lacerated lungs. He had a skull fracture, and every single one of his ribs were broken. What is called a collapsed abdominal, where he could not have breathed. So in saying that, Your Honor, 20 years is a manslaughter, 35 years is a murder. This is plain and simple a murder. He knowingly, intentionally drove that vehicle over the victim, and the state would be asking for 35 years, Your Honor.
All right. Mr. Gonzalez, I want you to know that I always reread stipulations. I always read the PSI report, and I always keep an open mind in listening to arguments from the defense and also from the state. And I understand that maybe if you had not been using drugs, maybe none of this would not have happened. We will never know, because we have to deal with what we're here for now. And what I'm looking at is the fact that you had someone who is merely trying to change their tire, and now they're dead through no fault of their own. So that's an issue. I know that any time that someone is sentenced to, it's difficult, because those are years behind bars that you're not able to do the things that you want to do. You can still see your family, but it's different seeing your family locked up as opposed to being in what they call the free world. But at the same time, there's someone who is no longer with us through your actions, and who knows what joy or happiness they were due to bring to this world, but you took their chance away from that. You took the chance of them being able to have more time with their family. Do you understand? That's either yes or no.
Yes, ma'am.
All right. So previously, the court found you guilty. The court is going to assess an affirmative finding of deadly weapon, taking consideration 2021 CR 9982, 2021 CR 9983, give you credit for any time served, and the court will sentence you to 35 years in the prison. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Ma'am.
All right. Is there going to be victim impact?
Yes, we have to.
All right. So members of the complainant's family are going to speak to you. I require that everyone in this court is respectful to each other. But as you can imagine, I'm sure there is heartbreak. Right? So just internalize what's being said. All right.
And there we have it. Two cases, two starkly different outcomes. One judge, Arturo Contreras Santos, whose defense hinged on a potential unconfirmed psychological disorder, received a 10-year prison sentence. His conscious knowledge of his crime outweighed any plea for leniency. In the very next case, however, an unnamed defendant is given a potential lifeline, a chance to enter mental health court and receive treatment instead of punishment, with the judge herself facilitating the process. It's a powerful demonstration of how the justice system navigates the complex intersection of crime, culpability, and mental health. The line between rehabilitation and retribution is drawn on a case-by-case basis. What did you think of the judge's decisions? Was the 10-year sentence for Contreras fair? Let us know your thoughts in the comments below, and don't forget to subscribe for more in-depth courtroom analysis.